Howdy, and welcome to the Legal Hour with Bailey and Galyen. I'm Keith Spencer, and we're here today at the Legal Cafe on the corner of Main and First in downtown Fort Worth. It's a coffee shop where you can come in and have a cup of coffee or a latte or some other fancy caffeinated thing and talk to a lawyer and get some ideas without having to go down to a law firm. Today we're here with Michael Galyen, and Michael is one of our top attorneys, particularly in the personal injury area. Michael, what kind of cases are you handling these days?
Well, Keith, these days I'm mostly handling work injury cases, which is a mixture between what we call in Texas non-subscriber cases and third-party cases.
I guess let's face it, the workplace can be a dangerous place. And in Texas, we've got oil field, we've got railroads, we've got some really dangerous professions out there. And Texas is a little different than some states in terms of how we handle workplace safety and injuries, isn't it?
That's true. Specifically, Texas is the only state that I'm aware of that does not require workers' compensation insurance. So there are a lot of employers in Texas who opt to privately insure their employees or not insure their employees at all. And so what that does is, in Texas law, our state legislature said, okay, fine, you don't have to get workers' compensation insurance if you don't want to. However, if you don't, your employee can sue you.
Okay.
And so that's what was often referred to as a non-subscriber, what I mentioned earlier. Their employer does not subscribe to the workers' compensation system, and therefore it opens them up to suit. And the other benefit you have as an employee who doesn't receive workers' comp is when you do sue your employer, if they've harmed you in some sort of way, is that they can't argue contributory negligence. So oftentimes, in a lot of cases, we deal with this idea of contributory negligence when we see the jury charge and they ultimately are determining who's at fault. There's blanks and they have to assign percentages to different parties. In this scenario, your employer cannot argue that you're 20% at fault or 30% at fault, or however they want to argue it. Now, I will add a caveat that there's a defense called sole proximate cause, that if you're the entire reason for your injury, then you are barred from recovering. However, people like to refer to it as you get your employer 1% on the hook and you recover all of your damages. So
okay.
You receive a bit of a benefit in that sense if your employer doesn't subscribe to workers' comp, but that's how we're different in that sense.
Do you find that it's mainly really, really large corporations who choose to self-insure instead of subscribing to the workman's comp? I mean, I think Walmart is an example I've seen before. At least at one point they were self-insuring.
Yes, I think that, right, there's two ends of the spectrum. One, there's the small ones who don't want to pay the workers' comp, and that's an obviously unfortunate situation. But then on the other end of the spectrum, it is the large ones, your Walmarts and Amazons, Targets, Lowe's, Home Depots. Those sorts of companies are the ones that will self-insure because it just makes more financial sense for them.
Okay, and so to be clear, the workman's comp system has been set up by the state, but it's like an insurance policy. You have to pay premiums to protect your employees and that sort of thing, right?
Right, and workman's comp is a no-fault insurance, essentially. As long as, and I don't practice workers' comp, but my understanding, as long as you show that you were in the course and scope of employment, the injury happened while you were in the course and scope of employment, then they're required to cover you forever, essentially, if that injury continues to affect you for the rest of your life. So that's the benefit of the workers' comp system. However, as I just explained earlier, if the employer decides not to get workers' comp, then they open themselves up to the risk of being sued by their employee.
Okay, so let's say that an employee is injured and for the purposes of this, we'll assume he was actually on the job.
Right.
It wasn't, during the coffee break, he jumped in the company truck and ran to get a latte
Sure.
and caused a wreck. But let's say you're injured on the job, and let's say it's a serious injury. What would be the first thing that you would recommend that an injured employee should do?
I would say the first thing is, if you need to call an ambulance or get medical care,
That's first.
Number one, yeah.
Call 911.
Please. But you also want to make sure your supervisor or your employer is aware. A lot of employers like to give pushback if they say that they weren't notified of the injury. And I failed to mention earlier, a lot of these employers who decide not to get workers' comp will still have this self-insured, private insurance type scenario, often called a work injury benefit policy or something like that, where they still will provide some medical care. They like to call it comp sometimes,
Okay.
and people think that they're receiving comp when in fact they are not.
Okay.
But a lot of these policies will have things that suggest you have to inform us of your injury within X amount of hours. So, yes, call 911, get an ambulance, whatever you need for your scenario, but then inform your supervisor or employer that you have been injured on the job and follow whatever steps are necessary through your employer or that plan that you need to.
I think we've all heard some horror stories about folks who are injured, and this kind of runs the gamut of people who've been injured. Frequently, there is someone there shows up, man, at the hospital bed with a check, saying, "Hey, sign here. I'll write you a big check," and then they'll accept a settlement, and then find out later that they're going to require multiple surgery or long-term care that they were unaware of at the time they settled. So let's assume someone's injured. They've notified their supervisor. They run and get medical assistance. What should their next steps be?
Yes, so if somebody is asking you to sign something after the injury, I do hear about that sometimes, especially in these scenarios with these work injury benefit plans, is they say, well, you need to sign this and sign this before you can receive benefits under the plan. Sometimes they may be harmless, but I would not take that risk. If you've been in that scenario, I would contact an attorney who's experienced with work injuries. I'm sure any of them, including myself, would take a look for you and let you know whether that's safe to sign. Because sometimes they're asking you, to sign something that may be harmless, and sometimes it may be bad. So I would definitely take the opportunity before you sign anything to call and speak to an attorney, send them the documents to review. If they're really pressuring you that you need to sign this in the next 5 minutes, 10 minutes, then it's probably not something beneficial to you. So they should give you the opportunity to have somebody review it.
There's not many times when, as an attorney, I can lay down a golden rule, but one of them is this: don't sign anything you don't understand, and don't assume that you necessarily understand everything you're reading. In the practice of law, like in a lot of other areas, we have defined terms, okay? And these may be words like we use at the kitchen table every day, and we think we know what they mean.
Right.
Okay? But in a contract or in a legal document, they're frequently specially defined terms, and they mean something else. I'll give you a great example. The word consideration. We all think we know what consideration means, and it has to do with etiquette and being a polite person. Not in a contract circumstance.
No.
In a contract circumstance, that means the money. Okay? So unless you are really, really confident that you know what something says, talk to someone, have someone review the document. Our firm will review documents and provide people with free consultations. So it's not like you have to go to war to figure out, before I sign this, what does it actually say?
Right, and you don't have to worry about paying money, like you mentioned. So that's
Right.
ideal. I mean, the issue, people run into this all the time, and I don't specifically specialize in contracts, but another big point is not reading the contract is not a defense. So a lot of people will say, well, I didn't read that, they can't hold me to it. That's not true.
Famous last words.
Yeah, if you sign your name to it, it doesn't matter whether you read that or not. They can hold you to it. So just be careful when it comes to signing things.
Well, and recognize too, folks, that you may have a great employer. You may really like your employer. They may really like you. They may be trying to do the right thing for you, but they don't hold all the cards, and they've had to purchase insurance, and they have to follow up with the insurance company requirements and that sort of thing, so that you're protected and they're protected. And we have a lot of great employers in this state, and nobody's trying to paint the employers with the tar brush and saying, oh, they're evil, they're anything like that. But we have some dangerous professions. I mean, gosh, look at the firefighters, just as an example. And you have a lot of private firefighters out there trying to help, and volunteer firefighters.
Right.
And it's a dangerous profession, okay? So you wanna be smart about what you're doing, and it's real important to remember that you only get one settlement. One.
Yeah, that's a fair point. And you make a good point that people may love their employer. Their employer may be thinking they're doing the right thing for them, right? But there are people involved with administering these plans who do it specifically for a living, who are trying to minimize what they ultimately have to pay out, right? Because a lot of the time it may not be your employer who's the one paying out come time for a settlement or verdict or whatever it may be. A lot of the time it may be this insurance company. So your employer, your supervisor, your boss that you're a buddy with, they may not be the person who's actually calling the shots. So just because you trust them doesn't mean you should trust this claims adjuster
in Minnesota.
Right, exactly. So that's just something to keep in mind as well. We're not here bashing the employers or those who decide not to get workers' comp. That's a financial decision that these companies can make. But ultimately, we're just trying to make sure you're protected when it comes time, if you suffer an unfortunate injury or anything like that.
We see on the news every day stories about really big verdicts that came down, and it's been my life experience that there's usually a pretty good reason when a verdict is really, really large. I don't see that many runaway juries in my life experience. What can you tell the folks about what's really happening when you see some of these big verdicts?
Yeah, that's a good point, right? The big money catches the headline: $2 billion, $3 billion, $500 million for a single event personal injury, right? A wrongful death of an individual or something like that, and you're thinking, while it's difficult for anybody to put a value on a human life, you're thinking, how did the jury come up with that number? However, in a lot of these cases that are catching the headlines, it's because there are punitive damages, or what are referred to in Texas as exemplary damages. And these are meant to essentially punish the wrongdoing defendant, right? So it isn't just, a company being negligent. There's a step further. And there's specific steps required under the law to recover those kinds of damages, right? So a lot of the time we think of, well, in order to get negligence, there are certain things that we need. We need the 4 elements of negligence. We need, if it's a jury of 12, we need at least 10 of them. There's the specific evidentiary standards. However, when you get to exemplary damages, those things are heightened. You need a unanimous jury, you need clear and convincing evidence, and you need to prove gross negligence, which is a whole nother matter in and of itself. So when you see these sorts of large verdicts, a lot of the time it's to punish these wrongdoing defendants, to essentially make a lesson of it, or to make sure that they don't do something like that in the future.
I remember a number of years ago, I had just started practicing law. There was an automobile manufacturer who was selling a car, and there were some questions about the gas tank and whether or not it was adequately designed to be relatively safe, and had a big lawsuit. I think some teenagers were in a car and it got rear-ended and it exploded and they burned to death. And while that's tragic, it was made more so by the memo that came in from engineering saying we can expect for about this many of these cars to blow up and people die, and it's going to cost us X dollars to fix that. but we only anticipate losing, something less than that from the lawsuits if we don't change it. And I think in that case, and it may be similar to what you're talking about, that's where the jury came up with the number of, because they made an economic decision.
Right, exactly. And so along those points, there are two different subsets of damages, right? There's economic, non-economic, and then I guess you'd say there's a third subset that we're talking about, exemplary. When we're talking about economic damages, that's your medical bills, your lost wages, future medical bills, future lost wages. Your non-economic, you're dealing with pain and suffering, mental anguish, disfigurement, all those other sections that are a lot harder to quantify. When it comes time for exemplary damages, at least in Texas, there are caps as well.
What does that mean?
So the jury can award whatever they like for punitive damages, right? But ultimately, after the jury makes that award, the judge will have to remit or lessen the damages to the statutory caps. At a certain point, the legislature said, we don't want the jury putting a aggressively large number on exemplary damages when the plaintiff in that case suffered, not as high of damages. So if their medical bills were only a few $100s, we don't want the jury then turning around and saying that this company owes them $1 billion because, what they did was just ridiculous. So the way that they've capped it is 2 times economic damages plus $750,000 is essentially there's a little bit more detail to it, but that's the quick and easy way to describe it. So, in some of these scenarios you see, well, somebody got a $150 million verdict, but there was only $1 million in economic damages. The verdict will get the headline, but ultimately what that person recovers and what the judge will put on the judgment does not equal the headline verdict. So, that's something else to keep in mind. I see sometimes people have expectations, right? And client expectations are something that we take very seriously. But I like to make it a goal from the outset to explain those things. And so, it's something to keep in mind that a lot of people like to think, especially because of the McDonald's coffee and all those sorts of things, that there's a lawsuit lottery out there and there's people just trying to
your
hit
ships
the jackpot.
come in.
Yeah, exactly. But that's just not the case. I mean, when our legislature has put some guardrails in place for those sorts of things, and even then, juries are smart, right? Juries are made up of you and I and all of our peers, and they ultimately decide what's a fair amount to give this person.
It has been my experience as well that one of the defining differences in this country is our jury system. And it has always been my experience that jurors are remarkably invested in providing a fair outcome. And I've never seen a jury or even a single jury member who I thought was there with an agenda. I think the jury system is very, very helpful. And I've been surprised how conscientious all the jurors seem to be in my experience. Have you found that?
I agree. I will say there's the process of jury selection that we call voir dire that does allow us to weed out those who may have an agenda, which is great because the plaintiff and the defendant will have a set amount of time to ask a whole bunch of questions. Mm-hmm. And a lot of the time, the people that you're suggesting that may have an agenda, they weed themselves out pretty quickly. Okay. You'll ask a question and they'll raise their hand and they'll want to talk immediately about something that's probably not even responsive to the question I asked. And, the defense counsel and myself and even the judge sometimes will look at each other and be like, all right, well, when it comes time to strike some of the jurors for cause, we know that individual is going to be stricken. So, right. But the vast majority, you're right, are not there with an agenda. They are truly there to make the right decision for the parties in front of them.
Sometimes people forget it's not really a situation of we're picking the jurors. we have a jury pool, and we're only eliminating those who really probably should not be on the jury because of an agenda or an infirmity or some life experience that they have that just makes it really difficult for them to be fair and unbiased.
Yeah, absolutely. That's a good point. There's two types of ways that somebody gets taken off a jury panel, right? There's for cause and peremptory. For cause is what you're talking about, in that they have an agenda, or we outline some sort of bias, or when we explain the law to them, they suggest, I understand the law that you're explaining to me and I just can't follow it. And we see that sometimes when we explain what sort of case that we're dealing with, and we ask the jury panel about it. So for example, I was doing a voir dire and explained that it was a car wreck case, and one of the jury members had raised their hand when I had asked whether or not people think they could be fair and unbiased when it came to car wreck cases, because sometimes people have life experiences, as you mentioned, that affect those decisions, and they come into the courtroom with those life experiences. And this person had said that their child was seriously injured in a car wreck involving an intoxicated driver, and that just before knowing any of the facts of the case that they may sit on, they just couldn't be fair because something is so close to home, it hit them that
Right.
they couldn't look at it objectively. And those are the sorts of things that we want to know, both plaintiffs and defense counsel, because we don't want jurors going in with a closed mind and certain life experiences that affected them so seriously that they can't go in with an open mind. And so those are the sorts of things that we also try and weed out during jury selection.
Okay. Now, you mentioned some of the caps on some of the jury awards, or awards from the bench, I suppose. What kinds of exceptions do we have to those caps?
That's a good point. So when we're dealing with exemplary damages or punitive damages, there is an exception for certain felonies. So, for example, there was a case that actually happened over in Dallas County, and I was listening to another attorney talk about a verdict he had gotten, and somebody had asked him the question, how they avoided the caps. And what was interesting is they forged the plaintiff's signature on an arbitration agreement. And so, there's an interesting concept that a lot of the time when you do anything these days, especially with some of these larger companies, you sign an arbitration agreement unknowingly. For example, when you're dealing with Uber and all these agreements, I accept the terms, I accept the terms. A lot of the time you're accepting an arbitration agreement, which means, unfortunately, if they do harm you or in some way, and then you ultimately would like to sue them, they'll pull out that arbitration agreement and say, we're not going to court. We're going to private litigation, which is referred to as arbitration, where you sit in front of an appointed arbitrator who's the judge, jury, and executioner, and he decides everything. And so in this specific case that I was referring to, it was dealing with a cable company that somebody was suing, and they tried to say, nope, we need to go to arbitration. And they ultimately determined through evidence discovery, depositions, and other things that was not that woman's signature.
Wow.
And the jury actually came to that conclusion as well. And so when it came time to award the exemplary damages, caps didn't apply. And they really got popped on that one. So, that's something to keep in mind, that while we did explain that there are caps to punitive damages, if the wrongdoer really does something wrong and they meet one of those exceptions, then you won't have to deal with those caps anymore.
That kind of goes back to read what you sign. And I know today, when everybody's online and they're signing up for an app or social media, and they say, please read the terms of the agreement. There's 47 pages, a little bitty type, or you can just hit I agree.
Right.
I think a lot of people just hit I agree, but it's kind of the same premise when we're dealing with litigation or injuries or dealing with the insurers. Once again, don't sign something you haven't read. Now, if it's just so that you can get the upgraded version of Solitaire, you may be okay. But what would you tell folks that you think would help kind of enlighten people about where the state of the law is in this area? I know that there's a lot of TV out there, and a lot of people think that they've got a pretty firm handle on the legal system and how this all works, and I think they're probably mistaken.
I think that's fair. The law is ever changing in most areas. I'm sure that's as true for family law as it is for personal injury. You'd think after how long we've been litigating injury cases in this state that all the issues have been solved, but that's just not true.
Every time you think you've seen it all.
Yeah, exactly. And so the Texas Supreme Court, as well as our appellate courts, have been coming up with new law recently that affects day-to-day things, specifically damages. I mean, we're dealing with I wouldn't say a complete overhaul in our non-economic damage system. However, the Texas Supreme Court has given us some extra guidelines these days that we're having to deal with. And, every term that comes around, all of us are keeping a sharp eye on the court. And I say all of us who follow it that closely. And I think that gets to your point of, when you're out there looking for an attorney, make sure you do find one that keeps their eyes on the sorts of changes in the law, because they're happening all the time. And if you miss it, some of the decisions you can make in your pleadings or at trial, or even in some pre-litigation matters, can make all the difference. So it's ever changing, and you got to keep your eyes on it.
I think that points out something else. An attorney can practice in almost any area, okay? And there's a real benefit in finding an attorney that is experienced in the kind of case you have. If someone says, well, I've done 3 divorces in the last 10 years, they're probably not an expert, because none of us can be experts in everything, okay? And so finding a good attorney can be difficult, like finding a good doctor for whatever physical condition you are.
Sure.
If you're not in the field, it can be kind of hard for you to know, well, how do I judge, who I should talk to? So if someone is dealing with a personal injury or a work injury, Michael, how do you think they should go about finding an attorney?
Well, first and foremost, I got to plug ourselves, because Bailey Galyen does handle so many different areas of law, whether it's personal injury, workers' comp, family law, immigration, you name it, we probably have someone. And if we don't, a lot of the time we'll try and refer you elsewhere. But I will say there are other resources out there. It's tough to just see a commercial or click on the first Google ad, or I would hesitate to do that, because then you're just finding the person who's likely just spent the most money to get you, right? They're not likely an expert.
Mm-hmm.
Oftentimes you'll see things like board certifications that'll be helpful. That tells you that person is an expert in the field. Or you go to their attorney bio and just read about them. A lot of the time you can see exactly what they do. If it mentions that they specialize in a certain area of law, then maybe that's who you need. So do your own research. Be careful before selecting an attorney. That's an important decision. And just make sure that the person you're selecting is somebody that is trustworthy. Take the time to speak to them before signing up with them or signing any contract, like we've discussed earlier.
If someone wants to come see you about an injury or a problem they have, what do they need to do, and does it cost them anything?
Does not cost you anything. Bailey Galyen only charges a fee if we win, so you don't owe us anything. You can call 1-800-LAW-OFFICE. You can go to thetexasattorney.com, Galyen.com, Galyen. Ask for me. I talk to people all the time, and I will take the time to listen and really try and see what I can do to help you. And if I can't help you, I promise I try and go out of my way to find somebody who can. It doesn't work every time, but I don't just say, well, I'll try and figure it out. But I actually get emails sent out and phone calls made and really try and help people. So whatever issue you're dealing with, give us a call. give me a call. We'll try and help you out.
There's no such thing as a silly question, okay? We all have questions that, I know this will sound silly. It does not, okay? Generally speaking, we'd really prefer to hear the question so that we're all singing from the same song sheet.
Yeah, absolutely. If there's a doubt in your mind before signing something, before making an important decision of any kind, especially related to a personal injury, though, just give us a call, ask questions. It makes the biggest difference and can be a life-changing decision for you.
Appreciate y'all for listening to us today. We're Bailey and Galyen. This is Michael Galyen, and we're from the Legal Cafe today, which is a place where you can stop by and have a cup of coffee and talk to a lawyer with no fears or fees. Have a good afternoon.